Good morning. Were you Jamarcus Zarate Jones?
Yes, ma'am.
Did you get someone hired?
Well, I talked to 3 lawyers.
Okay.
Lori,
Keep in touch with Watson.
Lori Parenzo,
Mm-hmm.
Lori Crenshaw, and Kate John.
Okay. And so where are you on being able to get someone hired? Pull your pants up. Just wearing a belt doesn't do it. Pull them all the way up so that I can't see your underwear sticking out the front. And nobody wants to see it sticking out the back. You understand? Okay. So where are you on being able to get someone hired?
I'm not physically couldn't.
Are you working?
No,
Why aren't you working?
because of these charges currently.
Okay. Were you working before?
Yes,
How old are you?
I'm 21.
Okay. So you're on, have you been going to probation like you're supposed to?
Yes, ma'am.
So where do you live? Who pays your bills?
Family, deal with family.
Okay. Hi, good morning.
Good morning. I just wanted to make you aware, the charges haven't been filed yet. We sent over a hearing last week to second amendment because he was arrested again here in Jefferson County. So he has 2 more charges that should be filed.
What'd you get arrested for?
Just being with the wrong crowd all the time.
Sounds like you are the wrong crowd. You're not? You're on probation for theft of a firearm and you've been arrested twice now? Since this, right? Is that what you're saying?
Yes, ma'am. Well, he was arrested in March, but he was also arrested June the 18th for possession of marijuana and unlawfully carrying a weapon.
Have a seat in the jury box. We're going to have you tested and then I'm going to decide what to do. Mr. Jones, come back up, please, sir. So you only tested positive for amphetamines, and it looks like you have a prescription, but I want to go through real quick.
I don't know.
Hold on, let me read this police report real quick about your last arrest. All right, so Mr. Jones, obviously, hold on a second, you're on probation for theft of a firearm. You've been arrested, just last week before last, and were able, I guess, did you make a bond in the new case?
Yes, ma'am.
Because you're on probation for the felony offense of theft of a firearm, and because you were arrested in a vehicle that looks like, allegedly, obviously you've not been charged with it, but there was marijuana in the car near the seat where you were sitting. It smelled like y'all had been smoking marijuana, and there was a gun in the glove box where you were sitting. So I'm going to find that the bond that I set set in the motion to revoke your probation case is not in the best interest of our community. I'm going to find that because you've been arrested while you were on that bond, it is appropriate for me to raise that bond. And at this time, I'm raising your bond to $200,000. You can go back with the bailiff.
Who's this lady? Yes.
Hand it to the bailiff.
I'm trying.
You gotta try harder than being in a car with a gun and marijuana while you're on probation. You've got a motion to revoke your
I
probation.
understand.
Go with the bailiff. We'll figure it out. We'll get you a lawyer appointed and we'll figure it out. Previously in court, in cause number 242309, entered a plea of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
Just an update, Judge. Page 3 shows that Mr. Smith is unemployed. He tells me that he's been working for about 3 weeks at Post Subcontractors. He's a foreman out there, making about $21 an hour.
So I know y'all know what my concern is here, that there were 2 felony probations just in the last 5 years that were revoked in the last 3 years. 2 different probations, one here and one in Brazoria County. So I don't have good warm fuzzies about you being successful on another probation.
Can I say something? That was a whole another life ago. I've corrected my life. I've been sober for 3 years now. I've been focusing on nothing but working. This evading arrest was actually a discrepancy that I didn't pull over fast enough with the officer. And I haven't been living that way in over 3 years now. So if you give me a chance, I'll show you that I can do it.
Okay. Mr. Smith, any reasons not to go forward then? All right, so I'm going to give you this opportunity. I do hope you take advantage of it and that you really have made those changes. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a motor vehicle. Sentence you in accordance with the agreement you made to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm suspending that. You'll be placed on probation for 6 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then as you know, for all practical purposes, your case here in court is over. You'll be able to serve that sentence while you're out on probation. The other side, however, in this case, is you've already agreed to a 10-year sentence. So if you violate your probation, you have that 10-year sentence hanging over your head. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. You've probably already received that, but I'm required to read it. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. And it's my understanding take him down there, and something's going to happen on that misdemeanor this morning.
We're going to dismiss it, Judge, so
Okay.
I can walk down and see if I can find which court is it.
I think it's County Court 3.
I can walk down there.
Okay. Okay, so if we can just hold him, if you'll come back and let us know as soon as that's signed, so you don't have to get transported or anything like that. Okay? Yes, sir. 038. Okay, so Mr. Savoy, I've been talking with your attorney, and she's talking with your grandma, and I'm reading over all this stuff. And so, obviously, what I'd like to do is send you okay? You need to sit down again for a minute? All right, if you start feeling bad, just head that way, okay? All right. The fact that you are using marijuana while you're out waiting on sentencing on a felony, obviously, is not what you should be doing, right? And that makes me believe you need some help.
I don't need it.
Oh, yeah, you're going to get some help, all right?
I take the help, but I don't need it.
Well, if you do need the help, otherwise you would have been making better decisions, and you wouldn't have been smoking marijuana before you showed up today, right?
The only reason why, because my grandma, she was in the hospital.
But here's the thing, we all have issues. That's not, it's not a reason. You can't say the only reason is because she was sick. Everybody here has family that has issues. We lose loved ones. Those things happen. And when they do, you can't smoke marijuana to make you feel better. Because it really doesn't make you feel better, but very temporarily, if that.
Keep me calm.
Well, you're going to have to do something else to stay calm, no matter what happens with your grandma. Do you understand? Do you understand? Answer out loud.
Yes, ma'am.
Because what I'm going to do today is give you an opportunity to be on this probation and not put you in inpatient treatment. So you're going to get to go home with her today. But if she gets sick again and she has to go to the hospital and you get stressed out, you're going to go to probation and say, I need help. You're not going to start using marijuana because you're going to end up going to prison and not just rehab. Do you understand? So what I'm going to order some help though, and you are going to be required to follow all of those conditions of probation, even if you don't think you need the help.
Yes, ma'am.
So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement. I'm going to defer all proceedings and place you on probation for 4 years. You're ordered to pay a $300 fine and to follow all of the rules and conditions of probation. One of those is going to be that you are through the Spindletop ATAR program, and probation will talk to you about that. They're going to do an assessment to figure out what help you might need with feeling depressed, with using marijuana, with having anger issues, whatever it is. If they say you need to go to a 30-day treatment, then you're going to go, or you're going to be back in here going to prison instead of 30 days, okay? If they say you need outpatient, or whatever they say you need, I'm ordering you to do, whether you think you need it or not.
Yes, ma'am.
That's so that you can be successful. You're also going to be required, at least for some amount of time, to wear a drug patch. You have 2 days, 48 hours to get that drug patch put on. Probation can tell you where you can go get those done. You have to get them changed every 2 weeks.
Yes, ma'am.
Okay.
I had one before.
You did while you were on bond?
Yes, ma'am.
Okay, so you're going to have to wear that because and if they test positive, you know what's going to happen.
Yes, ma'am.
Okay. I had one other thing I was going to, hold on. Obviously, you cannot be in possession of any gun. Okay. Oh, I know. You're going to get your GED.
Yes, ma'am.
That should be important to you, just like it's important to me. So probation will tell you need to get that program started within probably 45 days or so. You need to start taking the classes, taking the test. It's only going to help you be more successful so that you can kind of break this cycle. I know you have your grandma. I know your history because I'm reading in here with regard to your parents, and you want to do something different, right?
Yes, ma'am.
So that's what we want you to do while you're on probation, is give you the tools to head your life in a whole different way. And getting your GED is going to help you get a better job and be able to do that, okay? So that is part of your probation.
Yes, ma'am.
All right. If you do everything you're supposed to on this probation, this is a great opportunity because you are not a convicted felon. So you can still get better jobs, you can still live places and go places, vote, all those things that everybody else can do. If you do violate your probation, you don't follow the rules, you're going to be back in here, you could become a convicted felon, and you could go to prison for anywhere up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, this lady right here is going to call you up at her desk when she's ready to go over your paperwork. All right, take advantage of this opportunity so that you can be out there and help your grandma. Otherwise, you're not going to be. All right. Okay, so now, good morning.
Yes,
You're Marcus Elam?
ma'am.
And Mr. Elam was previously in court, pled true to counts 1 through 7 in a motion to revoke unadjudicated probation, on probation for burglary of a habitation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
I do.
Are there any additions or corrections to the report?
No, nothing's been changed.
And it was unagreed. Mr. Lewis, you may proceed.
Judge, this is a situation where it's no doubt that Mr. Elam may
several mistakes while he was on his probation, not following up on his obligations. After speaking with him, he's been in custody this length of time here. He is definitely, from what he's telling me, willing and wanting to comply with the court's orders, and feels as though he could successfully complete his probation given that opportunity. He understands that his mistakes, has definitely been costly and put him in this decision. He understands that's totally on top of him, and of course he would like to address the court as well as far as his plans for the future, Judge.
All right, go ahead.
Yes, ma'am. I'm sorry for my actions that I did when I was on probation. And if you really, I would like to start over, get life, live with my family, go back to work, help my mother out, give her bill, and everything else, Your Honor.
Okay.
And Judge, I'm sorry, I was going to say, Judge, if I may, one of the biggest issues I explained and talked to Mr. Elam about was him not reporting like he was supposed to do over that span of time. And he expressed to me that at that time he was dealing with the death of his grandmother, as far as I think she was a big part of his support system. He does have, I've been in contact, several members of his family have contacted me about him, so he does have a support system that's there. I think she was a big part of it. And after she passed away, I think he kind of went astray at that point, my understanding, Judge.
What is the status of the 5 new offenses that are alleged?
Well, they should all be.
What happened? So what was the deadly conduct from August of 2023? What was the outcome of the, or I guess I'm trying to figure out what happened on all of them.
My understanding, Judge, is he has cases that are pending in misdemeanor court, but nothing here, Judge, that's been accepted as any additional.
I mean, he pled true to the deadly conduct, discharging a firearm, from August 16th of 2023. Can you tell?
I'm sorry, Judge, I didn't look him up after he pled through.
I know. I just want to know if I want to know that. I want to know the evading, the failure to ID from February of this year. I want to know what the status of everything is.
There was an obstruction in 2023 that was dismissed.
Birthday gentleman. Just said unlikely to prove.
I mean, he pled true to it, so obviously there's that. All right, Ms. Malfino, what's the state's position?
Judge, I'm kind of torn on him. Obviously, the concern is the length of time he absconded. I mean, it wasn't just a month or two. They looked for him for almost 2 years, a year and a half at least. And in that interim time period, regardless of them having been filed or accused or whatnot by the intake division, he has pled true to at least the court standard of having committed all of those new offenses while on probation. Although he has no felony convictions, it looks to me like you ordered him to ISF cognitive in 23. Mr. Lewis had made mention that he never went. I don't know if they didn't have a bed for him and eventually he timed out of that, or something happened and the new offenses came up and they would take him.
I think when he had the prior MTRP, I don't know if it was at the new case or a prior MTRP, I'm not sure, but ISF was ordered, but at some point, I guess after he timed out or something because he was released from the jail.
Do you have a record of that?
He hasn't been. He wasn't able to due to pending legal issues at the time, and he was ordered to complete moral recognition therapy in lieu of, but he never.
So it was the new offenses that were holding him up.
Correct.
You get an opportunity to be on probation for a burglary of a habitation, and I want to really make sure I've got this right. So you get a deferred probation for burglary of a habitation, 2nd-degree felony. You get out, you commit 3 new offenses, 2 deadly conducts, discharging a firearm, and an assault family violence on that same date. Regardless of what's come of those cases, you've admitted that something happened on that day, right?
Mm-hmm.
So you come in front of me on a motion to revoke your probation. I say, okay, let's give you an opportunity to go to ISF. But because I guess something else must have been pending, maybe misdemeanors or something, you don't go to ISF. So you end up just getting out, getting another opportunity, and then you go and evade arrest or detention and fail to ID. We're back here again. And you want to start over and you're sorry. Think about how that sounds. And you just quit going for 2 years, a year and a half, year and 7 months. You just think you were going to get to be out and we were going to forget about you? You know, I mean, how old are you now?
23.
23. You started this when you were 19. Feel like you're not taking advantage and you're not growing up and making better decisions.
And I think Ms. Isaac tried to work with him when he would show up to work with her, so, I mean, I don't object to revocation, Judge, and any opportunity that we can.
I mean, I don't know that it makes sense for me to do anything else. And it's just so frustrating, honestly, for me, for the young people to keep coming in here with offenses that have to do with shooting. While you're on probation for a felony, you're shooting. Then you get out again and you violate again and you take off. So I can't give you a fourth shot. That you've had your shots. I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. I'm going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You need to sign that and you'll get a copy of it. You do have some rights to appeal. You can talk to Mr. Lewis about that. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. Good luck to you. You can go back with the bailiff. You are Michelle Lee Cormier, and Ms. Cormier is charged with the first-degree felony offense of murder in cause number 25, DCCR 0153. Mr. Radford has filed, there's a motion to quash the indictment. The state has filed a reply. Obviously, I've looked through both of these. I guess I'm confused, Mr. Radford, when you say it doesn't allege the requisite mens rea for murder?
Judge, if I may, the common law has established that murder is when someone intentionally and knowingly causes the death.
But the statute is what we're going to go by.
Yes, ma'am.
Okay.
But I don't think it was the intention of the legislature to remove the...
Manufactures or delivers a controlled substance included in penalty group 1B, blah, 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 that's fentanyl, that's what the allegation is. And so it actually has the mens rea of knowingly deliver. It reads straight from the statute, so I'm going to deny that motion to quash.
Can I
Sure.
just make a brief argument?
Yeah.
Under this indictment, under the way that it's pled, if a doctor gives a patient fentanyl and that patient dies, then that doctor can be charged with murder even though he did not intentionally or knowingly.
Well, there's an exception. The next C, except as provided, well, where was it? I saw this. It is a defense to the prosecution under section B4, which is our section that the actor's conduct in manufacturing or delivering was authorized under chapter 481 Health and Safety Code or state or federal law, which I think would be the medical purposes. So there's an exception.
Is it my understanding then, is the court of the opinion that the state must prove that my client knowingly delivered fentanyl to an individual?
That's what the law says, and that's what the indictment says. Did then and there knowingly deliver a controlled substance, namely fentanyl, and that Shelby Irvin died as a result of ingesting and inhaling that into her body. So
that it's the opinion of the court that Ms. Cormier must have the requisite knowledge that she was giving her fentanyl?
I think that's-
I think
Go ahead.
what Mr. Rafferty's trying to do is box the court in here.
I'm not gonna-
My interpretation of the statute is just knowingly deliver a controlled substance. And that controlled substance, if it contains fentanyl, is enough for her to be guilty of this offense. If it contains fentanyl and causes the death of a person, then that gets us to murder.
Well, I think that's going to be another whole question because it's specific that
It says knowingly to.
knowingly deliver a controlled substance, namely fentanyl. So I think that's going to come down to maybe a jury question. I don't think that's, I'm not going to make that decision. That's not a,
Right.
I mean, that's just an element of the offense. So
I would-
the motion to quash is denied.
Yes, ma'am, I would submit that the statute is unconstitutional as drafted.
Okay. I'm not going to find the
I
statute.
understand.
I'm going to follow it as written.
Yes, ma'am.
All right, so that's denied. Hold on just a second. Then there's additionally, I don't see an order on that motion to quash.
I can.
I got one.
Okay.
So that's,
Oh, thank you.
then in addition, okay, I'm just gonna set that right there for now. There's the order. Okay. Mr. Radford has also filed a motion to reduce the bond, which is currently, hold on a second, let me get to all that stuff.
$500,000.
Thank you, ma'am. Oh, it's, you filed an application of writ to seek reduction. Currently set at 500,000. Okay. Do you plan on calling your
ma'am.
client? Ma'am, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You may proceed.
For the purposes of the hearing, this hearing only, we call Michelle Cormier on the issue of bond reduction. Can you state your name?
Just so you know, once she's under, I mean, there are, I don't let anybody go far, but if she's under oath, and I am allowed to take into consideration some of the underlying facts of the case.
Yes, ma'am.
We won't go far, but just don't want you to think that we're not, can't go there at all.
Yes, ma'am. I
Okay.
understand. Can you state your name for the record?
Michelle Lee Cormier.
And you are the defendant in this case, is this correct?
Yes, sir.
And your bond is currently set at $500,000, is that correct?
Yes, sir.
Can you afford a $500,000 bond?
Yes.
Do you have assets in your name that you could liquidate to make a bond?
My family does.
Your family can help you? Have you talked to your family about possibly helping you with a bond?
Yes, sir.
And how much, what kind of bond do you think your family can come up with?
100,000 or less.
100.
That's what all of them have told me.
100,000, you think they can make a $100,000 bond? Would it assist your case in the presentation of your defense if you were bonded out and could assist me in working on your case?
Yes, sir.
Where were you born?
I was born in Beaumont, Texas.
Okay, have you lived here how long?
I've been back down in this area since I was 13 years old, so.
So you pretty much lived here your whole life?
Yes, sir.
And you have family in this area?
Yes, sir. Jasper area, my aunt here in Beaumont,
Where would you live if you made bond?
the Golden Triangle, Beaumont, or Bader.
Who would you live with?
My aunt, my 83-year-old aunt that comes and sees me, or my son and his grandma in Bader. My aunt lives here in Beaumont, off of Major Drive.
If the court set conditions of your bond, including a GPS monitor and random drug testing, would you agree with that?
Yes, sir, I sure will.
What is your criminal history? Have you been to TDC before?
Yes, sir, I went for early rehabilitation back in 2013.
How much time did you serve?
I made my first parole, and I served 2.5 on that 10 because they sent me to safety. And I successfully successfully came off of parole July the 11th of 2023.
That's a witness.
I want to know, I'm trying to I think it's probably in this reply. What was Ms. Cormier in custody for
Or theft, if I'm not mistaken, Judge.
when this happened?
Yes,
Okay.
ma'am.
So the allegations here are that you were in custody for theft.
Can I rephrase that?
No, just
Okay.
answer her
Yes,
question.
ma'am.
In custody, smuggled in some drugs of some type in your vagina that you gave to someone else that the allegation is led to her death that had fentanyl in it. Am I correct?
That's it in a nutshell, Judge.
All right, go ahead, Mr. Coleman.
And you don't disagree with the judge's assessment that you, in fact, smuggled fentanyl into the jail?
I'm going to object to that. I think you said the allegations are, what he's trying to do now is bind her into a confession.
I'll move on, Judge.
Thank you.
While you were in jail, did you provide a controlled substance or substances to other fellow inmates?
Again, Judge, I'm going to object that is not relevant at this time.
I'll move on, Judge.
Thank you.
Where did you get those drugs?
I'm going to object at this time, Your Honor, to that.
I think any of those are going to go to her Fifth Amendment right against self-incrimination,
Yes,
Mr.
One last
Coleman.
question. When you were arrested on the theft offense back in November of 2024, did you have a pending felony drug case in Orange County? Had you been arrested for methamphetamine possession in Orange County?
Yes, ma'am. Yes, sir.
That's all I have.
What's the status of that case? Do we
Still
know?
pending as far as I know.
Okay.
I don't think it's been filed. But if it's orange, it could
They're
take-
waiting on
it could take
drugs
years.
testing. Okay, anything else?
No, ma'am.
No, ma'am.
All right, based on the criteria under 17.15, the information that I have, the nature of the offense, I'm going to deny the petition or the request for a reduction in bond. I think $500,000 is adequate based on the nature of all of those matters. All right, anything else then on this case?
No, ma'am.
Okay, we'll reset it for an announcement.
Thank you. May I be excused?
Yes, thank you.
Judge, for the announcement purposes, I am waiting on a report from my expert, and I anticipate that will be early June.
Okay, we'll just do a normal reset and we'll see where we are at that point. Thank you. You can go back with the bailiff. Ms. Bork, you're charged with the state jail felony offense of fraudulent use or possession of identifying information from November 1st of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Fabrication.
It's admitted. Is there any evidence that Ms. Bork is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of fraudulent use or possession of identifying information, sentence you in accordance with your agreement to a term of 9 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreed. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws